I'm Jason Sullivan of On Subrogation, and this is Rathbone Group's video series to help you with your subrogation claims. In a prior video, we discussed hearsay and how it's defined under the federal rules. In this video, we're going to take it a step further and talk about exceptions to the hearsay rule. There are two exceptions, or broad categories of exceptions. The first category, and the focus of this video today, are those exceptions where it doesn't matter if the declarant is available or not. We'll talk more about what that means. And we'll have another video that talks about cases, exceptions to hearsay, when the declarant must be unavailable. As we discussed before, hearsay is an out-of-court statement that's being presented to prove the truth of the matter asserted. The court does not trust those as reliable and would rather hear directly from the first person. There are some exceptions, and we're going to touch on just a few of those, where the court will allow an out-of-court statement to be stated by the person who didn't make the statement, even though maybe there are cases where it's not as trustworthy or as reliable, but in these particular circumstances, the court's willing to accept it. The first exception is the present sense impression. Now, a present sense impression is a statement describing or explaining an event or condition made while or immediately after the declarant perceived it. We have a case where a witness sees a motor vehicle collision and turns to another person and says, "Did you see that green car run the red light and hit the blue car?" Now, that person said the statement as they perceived, as they witnessed it. They don't have time to make up facts or twist the story or say anything different than exactly what they perceived in front of them. If that person who made the statement is not available, or even if they are available, and the other person they made the statement to is put on the stand, they can testify that I saw that car run the red light and hit the blue car. And that bolsters the statement by the first person who also, yes, they told me they saw the exact same thing. And the key thing here is the timing of it. It has to be at the time, at the moment, or immediately thereafter, after that perception, to be a present sense impression. On a related and very similar note is the excited utterance exception. The thought for this is a person making a statement while under the stress or the emotion of an event is not going to have time to, again, fabricate or twist the events as they've stated. They're just reacting. It's an automatic and visceral reaction to what has happened. If you're in a motor vehicle collision and you get rear-ended and you yell, "Man, that car just rear-ended us," and you are still under the stress and the emotion of that, third parties that you said that to could be brought into court to testify, yes, this person said this to me. You're under the stress of the event, and therefore the excited utterance exception is going to take it out of hearsay, which is normally not admissible. Recorded recollection is another one that comes up, and this is to address the memory problem. If you are a witness to an accident and you take down all the details, let's say you keep a journal or a diary and you just keep track of everything, every little minor detail that happens during your day, and you witness a car collision, you may write down the colors of the car, the makes of the car, maybe the driver's license numbers, exactly what happened. And then you're called to be a witness, and you're called 2 years later, and you don't really remember. Well, the fact that you wrote it down, assuming you wrote it down when you have a fresh and accurate memory of it, now that writing can be used. It's an out-of-court statement. That writing isn't something you're saying in court. That writing took place outside of the courtroom, and now we want to bring it in to refresh your memory. So a party that puts a witness on the stand, and the witness is having trouble, but they wrote down the events that they're trying to remember, can be handed that piece of paper, and they can refresh themselves with what that recollection is, and they can even read and give that testimony to the court. The recorded recollection allows a party to testify to things that they forgot but they knew at the time. Because a court doesn't want to give that statement any more relevance or importance to the jury than any other witness's testimony, that writing is not admitted as a piece of evidence, but the witness can go ahead and read it as long as they state, yes, I had a memory of these events, I wrote it down when I had memory, and this is a true and accurate recollection of what I wrote down. Another very common exception that comes up in subrogation cases is records of a regularly conducted activity. If you're an insurance company, you have a lot of people who work for the company. You have field adjusters who go out and write property damage estimates. You have bodily injury adjusters who review medical bills, records, and determine what the value of the injury is. You have people who issue those payments, people who audit files, and subrogation specialists who attempt to recover those claims. At the case of a jury trial or any trial in front of the court where you're putting on your case, you're going to have to prove that there was damage to a vehicle and the estimate was written. Fortunately, the court's not going to require each person at the insurance company to come in and give testimony as to their small part of the entire case. Rather, the court is going to allow one person to come in and testify to the business records and activities of that insurance company. They fit into this exception because it's normally conducted activity and it's prepared by someone who knew or had knowledge of it at the time, and the person can testify that this is how the company handles the work that they're doing. This is typical of their work, and this is the work that was done. It saves a lot of time and efficiency because now one person from the insurance company can come in and say, well, it's our business to review property damage and write estimates. And this person is an employee of the company and it is their job to write estimates, and this is an estimate that they prepared and placed in the file on this date. Now you don't need that adjuster to necessarily come in, but you do still have a person who comes in and gives the testimony that will prove your case. It's hearsay because it's an out-of-court statement. That estimate is all out-of-court language that is written by somebody else who's not testifying. But the court's going to allow it, fortunately, under the business records or activity exception. Finally, judgment of a previous conviction is something that the court's going to allow. In our other video, we talked about admissible evidence and discussed how conviction that subjected a person to a penalty of more than a year in jail could be admissible evidence to prove that they committed the acts that lead to a negligence claim and your right to recover against them for your loss. In this case, the court's not going to require the judge or even the clerk to come in and say, this is the judgment that was entered and I banged my gavel and said you're found guilty. Rather, the court is going to allow that record, that judgment, to stand on its own as an out-of-court statement, but an exception to the hearsay rule that allows the party to present it to the court as admissible evidence that the person indeed was found at fault or guilty of that criminal charge. And elements of that criminal conviction are part of your subrogation negligence claim, and therefore the person should be held responsible. Thank you for watching this second video on hearsay, exceptions to the hearsay rule where it doesn't matter whether the out-of-court declarant is available or not. In our final video, you'll see we'll talk about the final exceptions where the declarant must be unavailable. For On Subrogation, I'm Jason Sullivan, and that's the long and short of it.